Hello, good afternoon. This is Erick Widman from Passage Immigration Law, and I'm experimenting with both some new lighting and a new beard here. We'll see how long this lasts, but hopefully that's not too jarring. But very excited to answer some questions, and I had a key question about the fiance visa and the difference between the fiance visa and an immigrant visa for your spouse. That question was asked a couple times this week. So I'm going to lead off with that question. Many times immigration lawyers are asked, what's better, a fiance visa or an immigrant visa after getting married? So there are pros and cons to the two options. Overall, here's some general principles. If you and your fiance, let's say you're the US citizen and your fiance is a foreign national of another country, if you're talking about marriage and what's the best pathway to be together, let's look at the first option, the K1 Fiance Visa. So you, the US citizen, and by the way, you have to be a US citizen to petition for your fiance. That's one of the requirements. So you, the US citizen, would file an I-129F petition for your fiance, and the timing of this is challenging. It's not under COVID, under the legacy Trump administration procedures, which are still largely in place in the Biden administration. It is not easy to get this done fast. There are lots of delays in the first stage of getting the I-129F petition approved, and then maybe another 8 months, 6 to 8 months, the consular processing stage. So on average, our clients are getting the fiance visa approved a little over a year. So processing times vary. The individual circumstances of a case varies. We've worked with some fiance visa applicants who, before they came to us, were waiting for years for their fiance visas to be issued. So it's by no means a sure thing that you'll get it in a year to 14 months. But historically, looking at our data, that is the case for our clients. About 12 to 14 months from the point you file the fiance visa petition, that your fiance will then go to her interview and enter the US to marry you. And your fiance has to marry you within 90 days of entering the US. There's another big step after you get your fiance here, and that is applying for the green card. And USCIS makes you do an adjustment of status following entry on the fiance visa to marry you. So looking at the big picture, if you're going with option one with a fiance visa, and you are happy that it's probably a little faster than the immigrant visa for your spouse, a downside is that you still have to do a big green card application, the adjustment of status for your new spouse in the US. And that can take up to a year, but it's roughly 6 months from the time that you file the adjustment of status application, 6 months for your work permit to arrive. So your new spouse is not going to be out of work for a full year. But it'll take, on average these days, about 6 months for that EAD work permit to arrive. In contrast, if you and your spouse, instead of doing a fiance visa, got married, and then you can't do a fiance visa because you're now married, so you'd petition for your new spouse, your foreign national spouse, to join you in the US. Right now, we're seeing for our clients about 14 to 16 months from the time that you file the I-130 to the time that your spouse arrives here as a new permanent resident. And overall, the costs, the filing fees, and also the attorney fees are a bit lower for an immigrant visa for your spouse as opposed to a fiance visa plus green card. The reason for that is there's less paperwork. There are fewer moving parts. But it'll take a few months longer on average for your spouse to arrive in the US. And a benefit, though, there's pros and cons. There's positives and negatives. A nice thing about the immigrant visa for your spouse is that you don't have to do an adjustment of status after that. As soon as your new spouse arrives in the US, she has a stamp. She's given a stamp that allows her to work immediately. She's immediately a permanent resident, and the plastic green card will show up roughly a month later. So there are certain advantages and disadvantages to both approaches. It's a tough call. It's a close call. And many times, one of the biggest factors that I recommend a couple figure out is, where do you want to get married? Where do you want to celebrate with friends and family? If that's really important to you, then it's probably worth it to wait a couple extra months or spend some extra money to do the fiance visa in the US, if that's the case. Or if your foreign national spouse is outside the US and you want to get married in her country, for example, or have all the relatives come to Dubai, that could then determine, that could be the most important factor for you. But since there are so many different factors, decide which factors are most important to you and then try to get the immigration system to work to fit your schedule. The government's supposed to work for us. We're paying all these filing fees. So that is the starting point. How can we get the US immigration system to do what we need it to do? Okay, that was a big overview on the fiance visa versus immigrant visa. And jumping into the questions now. Here's the first one. I am now qualified to apply for citizenship, but I need advice on how to proceed. They said that the process takes years. How true is that? I probably need a lawyer for this, but I'd like to know the general info. That sounds good. Citizenship is a huge, exciting step. It's an important step in that you need to make sure that your green card, that is a prerequisite, that everything was fine with your green card before you apply for citizenship. But here's the broad overview. If you are a permanent resident and you've been a permanent resident for 5 years, you'll be able to qualify on your own. That's the minimum period required to then naturalize. But if you are a permanent resident and you're married to a US citizen, your spouse is a US citizen, you're able to naturalize faster. And I apologize, you might hear it in my throat, but I've been fighting a cold, even COVID. But yeah, thanks for your sympathy. It wasn't that bad for me, I'm very grateful to say, because of the vaccine and the booster, but I can feel it in my throat. So keep pressing on here. Citizenship for a foreign national married to a US citizen, you can apply for that in 3 years as opposed to 5 years. One of the main differences, though, if you are considering 3 or 5 years, as part of the citizenship application, you have to show a genuine marriage and that you're currently in a bona fide genuine marriage, you're not living apart, and that you and your spouse have a viable relationship together. Sadly, some people get divorced, of course. And so if you're separated or on your way towards that end, you won't be able to do the 3-year naturalization period unless there's some exceptions there. So watch out for the exceptions. But you're able, the first key thing to keep in mind for citizenship, is it 5 years or 3 years? Then you also want to look to see if you've spent the minimum amount of time in the US. So there's 2 key tests for naturalization. There's the physical presence test, which is otherwise known as the boots on the ground test, where 50% of your time must have been spent in the United States. Half of your time must have been here to qualify to naturalize. If you've spent too much time outside the US, and if you don't have enough 24-hour days in the US, you are not eligible because of the physical presence test. You'll fail that, and you've just got to spend more time in the US to build up the minimum number of days to exceed 50%. So we've had some clients, we look at their time spent in the US and see that you're gonna have to spend another 60 days here to make sure in the last 5 years you've spent 50% of your time. So crunching the numbers, you can calculate it out exactly how much time you need to be here. The second key test is the continuous residence test, and that is a little fuzzier. It's more subjective, and that requires that you've maintained sufficient ties and connections to the US so that you didn't break continuous residence. So it's a balancing test. The factors they look at are things like, where's your job? Is it in the US or abroad? Where are you residing? Where's your apartment or your home? Are you living most of the time in the US or outside the US? And the list can go on and on. But if you, as a permanent resident, have spent a lot of time, more than 6 months outside the US, living abroad, you have a job there, those are all the subjective factors that could accumulate to say, the officer will say, you don't have sufficient ties and connections, you haven't spent enough time in the US so that you've had continuous residence. So that could break your continuous residence, and you can rehabilitate that by spending long interrupted periods in the US. Watch out though for past periods of time when you broke continuous residence, and you want to look carefully at that, because in some cases you might have abandoned your green card. That's the worst case scenario. Make sure you've spent enough time in the US to meet both those tests. You pay your $725 filing fee. We recommend filing online right now as opposed to paper. That's going a little bit faster. And for the most part on the West Coast of the US, we're seeing less than 1 year processing times for naturalization. Then you go into your interview and you have to memorize the civics test answers. You have to make sure you answer 6 out of 10 questions correctly. So those are the key steps for naturalization, and that's the big picture for you. Any other specific questions, definitely reach out, support@passage.law. All right, next question. My brother-in-law is waiting for his petition. How do you expedite the process? Okay, so it is tough asking these questions because sometimes the questions are really deep and extensive and it's hard to answer the question. Sometimes we need more facts, need for more info. But let me see if I can assume some things here to help answer the question. My brother-in-law is waiting for his petition. How do you expedite the process? So it's probably an immigrant visa for your brother-in-law, and a sibling most likely petitioned for your brother-in-law, or it could have been one of his parents or even a spouse. So we don't know for sure, but most likely an immigrant visa petition was filed, which is form I-130, and you might be waiting at the I-130 stage with USCIS because that's the petition part of the two-step process. There's a petition and then there is a visa application. The I-130 petition takes, on average for an immediate relative, about 6, 7, 8 months for that to get approved. So if you have a compelling reason why that should be sped up, you can request that to be expedited with USCIS. And there are expedite criteria that USCIS has where there's a urgent humanitarian compelling need, often a medical need, or severe financial loss. That's another reason why you could request the petition to be expedited. You can also seek to expedite the second main stage of the process. That's consular processing. So after the I-130 petition is approved, then your I-130 petition is sent over to the National Visa Center, which is part of the US Department of State, and they are in charge of collecting all the supporting documents that the embassy is going to need to approve your visa at the interview. So you can ask the NVC to expedite your application and putting the petition and the visa application together. That's what you need in order to get the immigrant visa. That's what your brother-in-law is going to need. So you could request that with the NVC as well. And sometimes it varies depending on the embassy. You're supposed to contact the embassy to get the interview set up quickly as well. We've seen both the NVC and embassies get involved in the expediting process. Okay. I applied for my N400 in September. This is a new question. Applied for my N400 in September 2020, and my countdown timer recently ran out, and now I just have the generic "we're taking longer than expected" message. Any ideas where things are at in the Portland area? So N400 is for a citizenship application, which you'd filed back in September 2020. And most likely when you're looking at the average processing times for Portland, it used to show average processing time is maybe 14 months or so, and that you were able to follow up with a case that was filed after a certain date. Or in that instance, it must have been filed at least by this date before that time. Otherwise, you can't follow up for it. I think that's what you mean by countdown timer, because now you're just getting a generic "we're taking longer than expected" message. And so you don't have average processing time listed. You don't have a date provided that says you can now follow up with a USCIS e-request, for example. So in the Portland area, our law firm, we do a lot of citizenship naturalization cases, and essentially all of them have been handled in a 12-month time frame. So sometimes faster and rarely not longer than that. So yours is definitely past, what are we at? About 15 months now, because it's January, October, November, December, January. So about 16 months. So you're definitely beyond that 1-year period here in January 2022. So you should follow up. You should be, phone call and e-request. You could have a law firm bug them, which we do for clients. And eventually, one of the few avenues that are open to people is a mandamus lawsuit. Hopefully you don't have to resort to that, but sometimes that's what it takes, especially if you are from a country that has been traditionally discriminated against. And so Muslims, for example, have been subjected to a series of unfair background checks based upon your religion. So that's not fair, and that's unconstitutional. And many Muslims have had to wait an unreasonable period of time, which affects your ability to get different types of jobs, to vote, of course, to petition for family members. So many people have cases that are delayed, but oftentimes there's discrimination against certain countries and certain religious backgrounds, which is unfair. The government doesn't admit this, but there have been FOIA requests, Freedom of Information Act requests, that show special secret programs, which are no longer secret. One is called CARP, CARRP, that was all about the government's efforts to do unfair, extra lengthy background checks, discriminating against people unfairly. So I don't know the background for you. It's been about 16 months since you filed. I would encourage you to start following up, and if the government is saying, "Oh, we not going to let you do an e-request," at least do a phone call. One of the things that we can do, we have contacts with the AILA liaison, and that is American Immigration Lawyers Association. We have a contact that we can speak with on our behalf. We kind of pool our resources and ask for advocacy for certain cases. Could you please check on this case? That's effective, as is the senator's office. But you don't want to go to the senator's office first. You want to time it just right and use them when it's the maximum effectiveness possible. Okay, well, we're doing a shorter period today. It was great to connect and look forward to seeing you next week. We're going to have more questions and we're going to get into more business immigration. Then I'm going to try to bring on our new business immigration attorney too, David Lee. We're also doing Friday webinars, which we're excited about, that will be focused exclusively on business immigration. This Friday, we're doing one on the H-1B visa. So stay safe, take care, and see you next week.